સાહેબ સાહેબ સાક્ષી આ સાહેબ લઈ લો સાહેબ
નેક્સ્ટ ટાઈમ ફાઈવ કરશે.
હા અને પછી then
સાક્ષી રાખીને લઈ લો સાહેબ.
એમના જે ધક્કો ના ખાવો
હા,
હોય
હા.
તો પછી
પછી
નેક્સ્ટ ટાઈમ હું રજૂ કરી દે
હા.
હા તો it will do.
હા
અને પછી then you will have to write
હા.
હા સાહેબ
but he'll have to say everything in on record.
હા
હા.
એ તો આપી
આજે નથી લાગતું હું રજૂ કરીશ.
કોપી રજૂ કરી
તો we are taking.
હા જી
ઓકે
Taking within 5-10 minutes.
ઓકે
ચલો next. What is the third matter of pen?
વકીલ સીબીએમ દરજી એને કંપની નથી
Private party. હા તો પૂરું કરી દઈએ ને આપણે તો we make one judgment. હા હા ચલો next જોઈએ. તો હવે we may start.
2014 ની હતી છે ઇમિગ્રેશનમાં પકડવા ઉપર પર
મીડિયેશન માં તો ડાયરેક્ટલી they should go to પણ call out કરો જો કોઈ તો અને what is it?
કેશુભાઈ હીરાભાઈ રાઠોડ રણધીરભાઈ કેશુભાઈ મધુબેન કેશુભાઈ હીરાબેન કાંતિભાઈ શૈલેષકુમાર કાંતિભાઈ દિનેશભાઈ કાંતિભાઈ અરવિંદભાઈ કાંતિભાઈ સુનીતાબેન રમણભાઈ સુનીતાબેન અમિતાબેન રમણભાઈ
One is the pen.
વિઘ્નેશ કુમાર રમણભાઈ એમએસ કલોસુરા
And we have got 57 minutes. અને ભાઈ ત્યારે 1 minute. Last year. March 30 अच्छा અને who is the other side law? So his client is not. अच्छा. So now help them in mediation. अच्छा એટલે હા
એ મજૂરી 17-5 ચાર્જ લીધું છે એમાં આઈલેન્ડ
સપ્ટેમ્બર ક્વાર્ટર યર ડેલિવર 3 days.
ડિસેમ્બર મહિના તો
Very
ચાર પણ
very Shall we start here? Yes, Mr. Bhavsar.
Hi, there is one matter, sir. Filed by Bank of India, sir. CMA 10/20.
Right. That delay condon matter.
Yes, sir.
You are ready with your argument?
Yes, I'm ready.
Because they have given in writing.
Writing and do not remain present with authorized person to settle this matter.
Okay. No, they did not remain.
Not
Because they said that okay. He said.
vague reply is given.
That. bank would not have been power. Because ultimately this is bank. એટલે now who may take care? Which bank is that?
Bank of India, sir.
Nationalized bank.
Nationalized bank.
Who I tell you, all nationalized bank must be closed. And only private banks should be there.
Yes. Yes, sir.
And they must be regulated in a good manner.
Good manner.
That you lend the money.
Even sir, there is a notification of Reserve Bank of India 2011, sir. These bankers, sir, do not sign on a copy of the bank account, sir. And yesterday charged for 1,400 rupees for getting account copy by State Bank of India. And that amount is debited in my client's account. How they can charge 1,400 rupees per?
He'll have to fight. Go to consumer court and get them set right.
Definitely, I will file complaint, sir, in consumer court.
But that will be.
They have no right at all to charge 1,400 rupees, sir. That is too much. And they are duty bound to give a copy of the bank account statement, sir.
Special other than money, zero. How much data? Yeah, we dispose of just every matter. One fixed money and two regular. In entire year. Entire year. Then like we have looked at a good number of them. This
ચંતીભાઈ મુળાભાઈ સોલંકી મુળાભાઈ સોલંકી ઉંમર 59 કોન્ટ્રાક્ટર રહેવાનું મોરવાડ તાલુકો મોરવાડ તાલુકો પ્રાંતિજ ખોટું બોલું તો ભગવાનની સામે
Sir, with respect to my credibility of form, sir.
This branch.
Yes, sir, same branch. Same branch, sir. Now, Your Honor, I will see that according to my written statement, sir, I have very specifically mentioned, sir, that in para number 5, sir, the bank authority intentionally remain absent and try to settle liability on one or other employee to suppress their gross negligence act, that the act of non-submission of claim letter of credit by sending all documents provided by plaintiff prior to the expiry of date of LC, I mean before 30th October 2019, to the State Bank of India Commercial Branch Ahmedabad, which is gross negligence on the part of the appellant bank. The plaintiff has not received payment of rupees 14,59,500 in spite of the plaintiff's letter dated 12/12/2019. The appellant have failed to credit the above said LC amount in plaintiff's current account. Later on dated 10th January 2020, sir, after lapse of LC, sir, on 30th October 2019, sir, reply was given, sir, late by literally, sir, 2 months, sir. On January 2020, the appellant got vague reply from the appellant bank. In the above all the circumstances, the appellant bank from very beginning act in unlawful manner and also shown gross negligence to act as a banker and put the plaintiff suffer big financial loss which forced him to file the subject suit against the appellant. Therefore, the appellant act in unlawful manner and do not act as a responsible banker, hence do not reserve for any the condonation of delay. This is a very much important, sir, because the interest of both the parties are required to be prevailed, sir. While even considering the delay condone application also, sir. The further say and submission paragraph 3 of the appellant that the plaintiff did not inform the appellant and file execution petition, that I have argued, sir. We submit with due respect that the plaintiff put reliance on the appellant's promise while executing warrant that the said payment was made entirely amount and execution petition within 1 month. Appellant now filed this controversial application, do not fulfill his promise to pay. Then, sir, Honorable Court may kindly see a paragraph number 8 of my written objection, sir. In spite of that service of summons on 19th April 2020 to remain present do not appear to defend the suit and Honorable Lower Court passed the order to proceed with the suit ex parte on 8th October 2020. After framing issue and matter was adjourned on 20th November 2021. The stage of plaintiff's evidence appellant do not appear to contest the suit up to disposal of the suit on dated 6th November 2022. Keep mum up to 10 adjournments, sir. 10 adjournments. Sir. Hence, the applicant or delay condone deserves to be dismissed, sir. Now, Your Honor, may kind of see that filing of such kind of vague application, sir, without anything, sir, in application itself, sir, with respect to knowledge of the filing of my suit, sir, with respect to knowledge of on which date they have got the summons, sir, which is earlier served in 2019, sir, April, sir. That is also not mentioned, sir, in their application also, sir. They have not taken any action, sir, against the person concerned who is having failure to appear before this honorable court, lower court, sir.
Have you seen the record? Summons was served to the bank.
Yes, sir, he admitted, sir, in delay application.
They have admitted the
That
fact.
will para 3, sir. The appellant admitted. Someone, but by mistake, sir, para 3 is clear.
So ground under order 9 to 13 goes, sir.
Sir, this appeal for person 96. Let's see, this appeal under 96. Sir. At that time, I have not a file, sir, but I have seen a file. So, as per 96, section 96.
I think this appeal. Okay, since you are a candidate.
Yeah. Wrote down in the appeal memo.
No.
Sir, read, sir.
No, I'm not done. I'll read it.
No, absolutely.
Enough.
Yeah.
Appeal at 96 April for India.
Okay.
Isn't 96?
Let's do that.
Isn't
Ah.
96 months?
Oh, right.
Yes, sir.
Chalo, 96 my your appeal is not maintainable.
It is written down by the previous lawyer. Sir,
Okay.
appeal under section 96 of CPG against the judgment dated 6/9/2022 passed by G.C. Waghela, second additional civil judge, Himmatnagar, granting the petition ex parte in the regular civil suit number 69 of 2020, and the valuation of the suit appeal is INR 17,89,217 paisa for recovery against LC and permanent injection.
Why tell you?
The primary decree.
Have you just you read the order
41.
43? Order 43. Order 43, clause D. An appeal shall
Yes.
lie
An appeals,
read.
an order under D,
Read.
an order under Rule 13 of Order 9 rejecting an application in case open to appeal for an order to set aside decree passed by ex party.
Right.
એટલે સાહેબ એમાં
So
એવું છે
you have
Sir.
got two remedies.
હા
Number one, you could have filed it over there, and once it is rejected,
rejected after
yeah, you could have come under this provision.
41 માં લખ્યું સાહેબ કે અરજી પર અરજીના હુકમ ઉપર
Hmm.
930 ની અરજીના હુકમ પર અપીલ સાહેબ
Hmm.
ગુજરાતીમાં એવું લખેલું સાહેબ
Not right.
in bracket.
If application is rejected, so then you could have come over here in appeal under 43.
This order.
Right. એટલે you have lost your two remedies,
Two
three
remedies.
remedies
3 remedies.
by directly coming over here. Chalo, okay.
Okay, sir.
Well, now even there is one catch. You just look at order 96, sorry, section 96, which say that appeal shall lie from every other degree, but whenever it comes to ex parte decree, an appeal may lie. Now, may lie means only under certain circumstances, not under all the circumstances.
May lie.
So, now that question will have to be dealt with. But right now we are on the point of.
Okay, sir.
Yes, Mr. Bhatt.
Yes, sir. Now, look, I have seen that the application of delay condone, sir, even in prayer, para number 8, sir, it was nowhere mentioned, sir, that how much delay is caused, sir, on the part of the applicant, sir. Much more, sir. No,
How many days delay?
as per their case, sir, they say 75 days, sir.
Okay. How you have counted 75 days?
It is not mentioned, sir. That in which date, sir, they came to knowledge, sir, is required to be kindly considered, sir. Now, Your Honor, I see they are within the knowledge, sir, of a decree, sir, as and when, sir, the execution notice is served, sir, on 15th November 2020, sir. From that day, sir, it is required to be considered that they have to prompt enough to file an appeal before
What is the date of judgment?
judgment is, sir,
So, no,
6/9 September. 6 September, sir,
अच्छा. It
22.
was ex parte judgment.
Huh.
Sir, ex parte.
Okay. When it came to their knowledge about judgment,
They say, they themselves say, sir, in their application itself, sir.
આમાં સુધારો
On
આપણે કોપી ના જઈએ પણ આમાં 170 days at the time of filing સુધારો
170,
અહીંયા લખવા છે 170 100
amount was less, 2 lakhs.
huh?
અહીંયા લખી જશે 180 days 118 દિવસ 118 days
Okay, this is the record.
Very good.
અપીલ દાખલ કરતા
One time, never purchase. No, there's no guy. No. Because we are doing, therefore I know that it is.
એટલે મેં
કઈ તારીખે દાખલ કરી છે application?
How many cases?
There are so many.
And
There are other offenses are also there.
અને પેલી that other is ready? Okay. I have to both together. And if need be, you may show it here. So, soft copy. I'll look at it. Okay, what was the ground why we have rejected? Though it is 2 lakhs, what reason we have given that?
15/2/23 ને તો ઘણો દિવસો ઘણો
28 12/22 પછી બે લખી પાછું આગળની તારીખ આવે. પંદર બે બે હતી. 15 બે બે હતી.
Go ahead. They are being defended in English. Because I used to do it.
So one clarification, yeah,
Right.
not a 75 days, 118 days. સુધાર at that time filing વખતે સુધારો કરેલો છે પેલન્ટ વાળી પણ આમાં જે કોપીમાં જે 75 days લખાયેલા છે એ કોપી એટલે at that time filing માં લખેલું 118 દિવસ લખ્યા છે.
Acha. So what was the date of knowledge?
15th November, as per their say, sir.
And how they came to know about this?
While service of execution petition, sir.
19th November,
15th November,
15th November.
Yes.
2023,
yeah, 2022, sir.
22.
Oh, yes, sir.
Acha. And when this application was.
This application is submitted, sir.
15
No, first of February,
15 days.
A notice issue, returnable notice છે, returnable date છે, એક બે, 1st of February, sir.
Oh, but this year.
Yes, 23.
Or updated. Right? Okay. Document to be done upon.
આમાં સર એપેલન્ટે જે ડેટ ટાઈમ 6/1/23 સર્ટિફાઈડ નકલમાં ગઈ એટલાથી કરી છે ઉપરનો પીરિયડ સાહેબ જે ડેટ ઓફ નોલેજ ને બધું પ્લસ માઇનસ ઇક્વલ નથી બતાવેલું. અહીંયા થર્ડ પેરામાં ડિસ્ક્રિપ્શન આપેલું છે કે ભાઈ ડીલે માટેનું order of the 6/9/2022 thereafter respondent original petitioner didn't inform to us and filed the execution petition before the honorable second additional civil judge and proceed against us where we received a summons the execution petition 15/11/2022
15/11/2022.
15/11/22
Okay. And then what did you do?
there yes sir
After
अच्छा આગળ લખ્યું છે where date of appearance is 23rd 11/2022 એ દરખાસ્તના કામે જ હાજર થયા સાહેબ.
ના ક્યાં હાજર
એને
થયા?
પેલું એન્ડોર્સમેન્ટ આપ્યું
હા એમ કહો તમે તમે એનામાં વોરંટ બજાવવા ગયા તારે એન્ડોર્સમેન્ટ
but
આપ્યું
due to
એ પહેલા નહીં સાહેબ, એટલે સર્ટિફાઈડ નકલ લાવ્યો છું.
due to the process of taking permission from the higher authority the engaged the advocate for proceeding of 23rd 11/2022 no one appeared and court issued the jangam warrant against us where we have taken the time for filing our reply and also to proceed the appeal against the order and decree before your honor, in which we have moved an application for certified copy of judgment and decree which we have received on 6 January 2023.
Now, Your Honor, may I say this covenant, sir, or pleading is also wrongfully stated, sir. As per the comparison, sir, along with the bond, sir, which is I have certified copy, sir. They sought for simply time for paying the money, sir. They have not appeared before the Honorable Lower Court, sir, in execution even. Even after getting summons, sir, of execution petition on 15 November, sir. They have not remained present, sir, before the Honorable Lower Court in execution petition itself also, sir. Reason based known to these people, sir.
Yes, sir.
They do not like small judges.
Evidence, sir.
Madam, look at this bank.
Not only that, sir. Due to these people's gross negligence, sir. મને સાહેબ જે છે એ લેટર ઓફ ક્રેડિટ મળ્યો 11 તારીખે 11/9 મળ્યો, બરાબર છે. 13/9 મેં બધા ડોક્યુમેન્ટ એમને આપી દીધા છે. તે છતાંય 30/10 એની એલસી પૂરી ના થાય ત્યાં સુધી સાહેબ બેસી રહ્યા અને 4 તારીખે 4/10 ત્યાં મોકલાયો સ્ટેટ બેંક કોમર્શિયલ બ્રાન્ચમાં સાહેબ એલસી જેને ઇસ્યુ કર્યું હતું એને. અને પછી સાહેબ મને રિગ્રેટ લખે છે કે આવું ફરીથી નહીં થાય. અમે તમે ક્રેડિટેબલ છો, તમે આમ તેમ આવું લેટર લખ્યું. હું વાંચું સાહેબ, આપજો પરમિશન આપો તો સાહેબ.
Unfortunately, I have no time otherwise. Otherwise, this is comedy matter.
હવે સાહેબ
Now you know, can you see that even in this condonation delay application, sir, Honorable Court may can you say that certified copy is only asked for by concerned person on 2nd January 23. Even getting knowledge, sir, with respect to decree passed by the Honorable Lower Court in execution service of notice of execution, sir, on 15th November, sir, they never cared even to know how kind of decree is passed, why decree is passed, and after even for getting certified copies, sir, for filing appeal, sir. So only and only this application was submitted, sir, by concerned person on 2nd January 23, sir. After knowledge of said decree, sir, on 15th November 23, sir. Now I can see that even in award, sir, it is and we say, sir, because award is produced with the application for getting the condonation delay. No judgment certified copy is produced, sir. Subsequently, they produce, sir. On last date, sir. But I may not say anything with respect to be at present, sir. But the Honorable Lower Court, sir, considering the facts, sir, in award itself, sir, very clearly mentions, sir, that what is the factual aspect, how the bank is negligent, sir, in not submitting the letter of credit, sir, in favor of me, which is issued by concerned bank, sir, in time. In the present case, defendant is a nationalized bank doing banking business in India and having one of its branch at Himmatnagar. The plaintiff is having current account and cash credit account with the defendant bank at Himmatnagar branch. Further, it is the say of plaintiff that plaintiff received swift message on 12th September 2019 by Himmatnagar branch from State Bank of India Commercial Branch Ahmedabad regarding opening of LC number so and so on 11/9/19. After receiving LC of rupees 14,59,500, the defendants advised having its expiry date 30th October 2019. The Bank of India Himmatnagar branch. State Bank of India granted LC facility to the applicant Sangres Tiles Limited, showing the name of the plaintiff, I mean Anupam Ceramics, issued in favor of the plaintiff documented credit, which was available by negotiation of draft of the plaintiff and 90 days of the invoice drawn on State Bank of India Commercial Branch Ahmedabad. account Sengers Tiles Limited bearing number, date and of issue and name of issuance bank of this credit for say 100% of invoice value accompanied. Further stated that after dispatch of materials, all documents were submitted to the defendant bank, I mean Bank of India. The same was acknowledged by the defendant bank. However, the defendant Bank of India failed to claim LC by sending all documents provided by plaintiff prior to the expiry of date LC, I mean before 30th October 2019, to the State Bank of India Commercial Branch, Ahmedabad. Further, plaintiff received a call from the defendant bank regarding return of documents from SBI. However, the plaintiff came to know that the defendant bank has failed to forward the document to the SBI in time, and due to the gross negligence on the part of defendant bank, plaintiff has not received payment of 14,59,500. In spite of that, the plaintiff's letter dated 12/12/19, the defendant have failed to credit the above said LC amount in plaintiff's current account. Later on 18th December 2019, defendant bank replied to the plaintiff and assured for the best services. How kind of service is rendered to me, sir? But later on 10th January 2020, પછી બીજો લેટર જાન્યુઆરીમાં લખ્યો સાહેબ. Plaintiff got vague reply from defendant bank. Further, it is say of the plaintiff is not in a position to recover any amount from Sengers Tiles Limited because the said unit is now sick unit and it will not pay the amount to the plaintiff. Therefore, we have to file this suit, sir. So even award, it is very clearly transferred, sir. Because finding is of the honorable lower court is on documentary evidence itself, sir. It is not finding, sir, of suo moto of filing of chief examination by plaintiff, sir. So even, sir, looking to the award itself, sir, from very beginning, sir, these people act in very gross negligent manner, sir, cause loss of 14,59,500, sir, to the present respondent, sir. Now I may kind of see that latest decision is rendered by their lordship, sir. This judgment is delivered by the Lordship Justice Sandeep N. Bhatt, sir, on 12th April 2023, sir. And in this judgment, sir, so many rulings were discussed by their Lordship, sir, while arriving at this rejection of arriving at the confirmation of rejection order by learned district judge, sir, in appeal, sir. Now I may kind of see that I may draw your kind attention to the page number 5, sir. The present respondent, original plaintiff and the opponent in the delay condone application is possessed the land in question is more than 61 years indisputably. When the state authority have suddenly removed some part of the hut situated in the land in the question without following due process of law, he has immediately approached the competent civil court by filing RCS number 705/89 for declaration of permanent injunction. The state authority have not appeared before the trial court. Though served, the trial court has not option but to proceed the suit ex parte. The trial court has allowed the said suit by judgment and decree dated 20th August 93 in favor of the plaintiff and directed the state authorities not to take survey number so and so and judgment dated 12th of April 23 possession of the suit land without any due process of law. The Revenue Authority has taken note of it and has matured the entry to the separate in the revenue record by entry number so and so. The state authority have not challenged the same before any higher forum in appeal proceeding and thus it has attended finality. After a long period, the plaintiff has against filed RCS number 50 for the declaration of permanent injunction before the competent civil court. In the proceeding, also the state authority, though served, has not appeared and contested the suit proceeding. Here in this case also, sir, in a suit summons, after getting summons, sir, in suit, they have not appeared. Even after filing by me execution application, they have not appeared before the honorable court, sir. So that is the basic negligence on the part of the present applicant, sir. Now, para number 14, sir, may kindly be perused, sir. While discussing the judgment, sir, in a special civil application 18,903, paragraph number, sir, 14 of 14 in page number 8, sir. 8. Yes, sir. While discussing the judgment, sir, hearing number SCA 18903 by 2021, sir, the finding of the High Court, sir, is also observed, sir, by their lordship. The High Court has observed that if the delay is condoned, no prejudice will be caused to the applicant, as the appeal would be heard on merits. The High Court has also observed that there is no willful negligence on the part of the respondent. Herein, nor it suffers from want of due diligence. However, this is important, sir. However, from the averments in the application for condonation of delay, we are of the opinion that it was a case of gross negligence and or want of due diligence on the part of the respondent herein, appellants before the High Court in filing such belated appeal. So here in this case also, sir, there is a gross negligence, sir, and also, sir, want of due diligence is there, sir. In the case of P.K. Ramchandra, while refusing the condonation of delay of 565 days, it is observed that in the absence of reasonable, satisfactory, and even appropriate explanation for seeking condonation of delay, the same is not to be condoned lightly. It is further observed that the law of a limitation may harshly affect a particular party, but it has to be applied with all its rigor. When the statute so prescribed and the courts have no power to extend the period of limitation on equitable grounds, it is further observed that while exercising discretion for condonation delay, the court has to exercise discretion judiciously. Now, I may lead your honor's kind attention to paragraph number 20 of this judgment, sir. In the case of Basavaraj Supra, it is observed and held by this court that the discretion to condone the delay has to be exercised judiciously based on the fact and circumstances of each case. It is further observed that the expression sufficient cause cannot be liberally interpreted if negligence, inaction, or lack of bona fides is attributed to the party. It is further observed that even though limitation may harshly affect rights of the party, but it has to be applied with all its rigor when prescribed by statute. It is further observed that in case a party has acted with negligence, lack of bona fides, or there is inaction, then there cannot be any justified ground for condoning the delay, even by imposing condition. This is very much important, sir. It is observed that each application for condonation of delay has to be decided within the framework laid down by this court. It is further observed that if court started condoning delay where no sufficient cause is made out by the imposing condition, then that would amount to violation of statutory principle of showing utter disregard to legislature. In the case of Pundit Jalaram Patil, it is observed by this court that court cannot acquire into belated and stall claims on the ground of equity. Delay defeats equity. The courts help who are vigilant and do not slumber over their rights, sir. Then in a 10th page, sir, paragraph number 6 of judgment of Supreme Court, sir. In Bhairulal and others, the object of such cases appear to be obtain a certificate of dismissal from the Supreme Court to put a scrutus to the issue, and highest court has dismissed the appeal. It is mere completion of formality to give a courtesy to the litigation and save the skin of the officers who may be at fault by not taking action in prescribed time. If the state government feels that they have suffered losses, then it must fix responsibility on the concerned officers for their inaction, but that ironically never happens. Then para number 29, page number 11, sir. Now, I may lead your kind attention to para number 29 of judgment in page number 11, sir. In our view, it is the right time to inform all the government bodies. Page number 11, sir. Para number 29, sir. Yes. In our view, it is the right time to inform all the government bodies, their agencies and instrumentalities that unless they have reasonable and acceptable explanation and there was bona fide effect, there is no need to accept the usual explanation, for the file was kept pending for several months and years due to considerable decree and procedural red tape in the process. Here in this case also, sir, this kind of explanation was given that summons was pending with some erroneous person, and therefore we have not able to file the appeal in time, sir. That cannot be a ground, sir, and acceptable ground, sir. Then para 13, sir, consider the fact that there was no proper explanation offered by the department for the delay except mentioning various dates. According to us, the department has miserably failed to give acceptable and cogent reasons sufficient to condone such huge delay, sir. Then I may lead your honor's kind attention to para number 12, sir. In para number 9 of judgment of money ban, Devraj Shah versus Municipal Corporation, sir, delivered by Honorable Supreme Court, sir. It is at page number 12, sir. Page number 12. And judgment of money ban received by para number 9, sir. Page number 12, sir. नीचे से बीजो सर पैरा 9. Yes. Prayer made by the corporation for congress of delay by ascertaining that the story of misplacement of the papers is unbelievable and is liable to be discarded because the applications for congress of delay do not mention as to when the misplaced papers were traced out by the concerned department. Here in this case also it is nowhere found, sir. એમને ક્યારે સમજ મળ્યો અથવા ક્યારે જાણકારી થઈ. Then on my kind of see para number
Then they had appeared in the court.
never appear, sir. Never. Do not appear, sir. Even getting warrant, they have not appeared before the Honorable Lower Court in a kind of application, any kind of objection, sir. Even vague in nature, sir. Then I may lead your kind attention to para number 24, page number 13, sir. What color the expression sufficient cause would get in the factual metrics of given case would largely depend on bona fide nature of the explanation. If the court finds that there has been no negligence on the part of the applicant and the cause shown for the delay does not lack bona fides, then it may condone the delay. Explanation given by the applicant is found to be concocted or he is thoroughly negligent in prosecuting his cause, then it would be a legitimate exercise of discretion not to condone the delay. Then, sir, lastly, sir, page number 15, sir. In between this page, sir. Page number 15, sir. Para number 11 by 5, sir. Fourth para of this page, sir. Okay. It is true that sufficient cause should receive liberal construction to do substantial justice. What is in CA number so and so, judgment dated so and so, sufficient cause is a question of fact in given circumstances of the case. It is true that control delay is a discretion of the court. Length of delay is no matter, but acceptability is the only criteria. Thus, the courts have taken a clear view that the intention of the parties in filing appeal belatedly also the delay cannot be condoned by exercising power by discretion. Therefore, all these aspects have to be considered, sir. So lastly, their lordship, sir, rejected, sir, this application, sir, and the order passed by the Honorable District Judge, sir, is upheld, sir, of rejection of condonation of delay, sir. So, Sandeep and Bhatt, sir, is fairly applicable to my case, sir. And I request Honorable Court to dismiss this application, sir, of condonation of delay, sir. That is my submission.
લેખિતમાં આપેલી સાહેબ એ નથી વિશે.
These are there.
No, simple journey.
Right. Only honorable sir.
But their lordships fairly discuss and consider so many judgments of Honorable Supreme Court. In one matter, sir, criminal appeal number 204/23, sir. There is a settlement between the parties, sir. And as per the settlement, sir, the amount which is deposited before this honorable court, 1,10,000, is to be given to respondent, sir.
Right.
So I request honorable court to consider this application and amount may kindly be. ના એમાં appeal છે અપીલમાં જ ઓર્ડર સાહેબે કરેલો છે જુદી અરજી નહીં કરવી પડે મારે એમાં જ ઓર્ડર સાહેબે કરેલો છે હા ઓર્ડર કરેલો છે એમાં લખેલું છે
He is right. He is right. You will have to file.
મને તો
He is right. Ah, okay.
આ લઈ લો સર સર્ટિફાઈડ આમાં પડી છે બરોબર સર
પેલામાં કેટલા કેસો પેલા આગળના Okay. And what was the ground for rejection? So just go back. So, okay.